Hi, my name is Mark Berry. I'm a staff attorney and lead housing attorney at Veterans Legal Institute. Veterans Legal Institute is a nonprofit law office which provides free legal assistance to homeless, low-income, and elderly military veterans. Today's video is a brief guide to provide you with knowledge about how to triage an unlawful detainer case. The following which I'm about to present to you is general and non-case specific information for educational purposes. This should not be construed as legal advice. Currently, California is experiencing a severe and escalating homelessness crisis, compounded by the lack of affordable housing, loss of employment during the pandemic, stagnating wages, among other things. Tens of thousands of people are either experiencing evictions from their homes or close to experiencing an eviction. The consequences of an eviction are severe, rivaling only those of a criminal conviction. As you are aware, unlawful detainers also receive priority in the court system over other civil matters, and both attorneys and tenants find themselves with very limited time to react. It is in essence the 100-meter dash of civil procedure. Many people who lose their homes in an eviction will not be able to find new housing in the future. They will instead join the ever-growing unhoused populations living on the streets of our cities. In Orange County alone, there were more than 10,000 unlawful detainer cases filed in 2022. As an eviction defense attorney, you are on the front lines of fighting the battle against homelessness. In many respects, representing tenants during an unlawful detainer is like being the triage nurse in an emergency room. Due to the sheer, unprecedented scale of the eviction crisis, you will be inundated with many serious and heartbreaking cases. With limited information and time, you will be forced to make quick decisions about whether you are able to represent a client, about what stage of the eviction the client is in, and what strategy you're going to take when representing that client. Your decisions can make all of the difference between the client prevailing in their case or losing their homes and becoming homeless. Therefore, it is imperative for you as a legal aid attorney to develop a rapid and efficient system of intake and screening of eviction cases, which allows you to learn the facts and develop a legal strategy as quickly and efficiently as possible. That is what I like to call the triage of unlawful detainer cases. This video will help you with developing a system to triage an unlawful detainer case for your tenant clients. As an attorney representing a tenant in an unlawful detainer, you should not wait until the initial client interview to acquaint yourself with the case or to decide on which strategy you want to take, or ultimately to decide whether this is a case you are able to assist with. Prior to the initial client interview, your office should request the prospective client to submit any documents which they have that can be relevant to their case. You cannot wait for the client to bring those documents to the initial interview. At a minimum, your prospective client needs to send copies of their summons and complaint, their notices to pay or quit, and any other documents relating to their eviction. You should also review the client's application notes carefully to get an idea of whether possible defenses exist. For example, if the client in their application alludes to their apartment being filthy or unsafe, you should also ask the prospective client to submit any photographs of the unsafe and uninhabitable conditions at their home. You should then take some time to review these client documents and acquaint yourself with the facts of their case prospectively. Well, obviously, there's only so much you can learn prior to the actual interview with the client. By obtaining and reviewing these documents, you will have developed a rough understanding about the relevant facts of the client's case. You can also determine a tentative strategy that you may want to take. Initial client interview. The initial interview is especially important in unlawful detainer cases. Notwithstanding your pre-interview investigation, you still cannot obtain a total understanding of the facts unless you've had a chance to interview the client. However, by preparing yourself beforehand, you already know what stage the case is in, whether you will be able to provide further legal assistance to resolve the matter. Furthermore, at this point, even before the interview begins, you should have already developed a tentative legal strategy. For example, when during your review of the documents, you observe that the attached notice to pay or quit is defective in some manner, you already know that you may need to file a demurrer instead of filing an answer to the complaint. Given the limited 5-day time frame to file an answer, the initial client interview may be the only time you speak with your client before taking a critical step in their case. Therefore, it is especially important to take the time to thoroughly understand the facts of the case before your client interview. During your client interview, you must also use the opportunity to allow the client to feel heard, to build rapport with them, and to have them gain trust and respect for your expertise. However, given the limited amount of time, you should make sure that you set specific parameters for the scope of the interview so as not to delay your ability to respond to the case. You should open the interview by asking the client to give a brief recap of the story of their case. However, given that your time and your client's time is limited, and since you already have gained a general idea about the facts of their case, you should direct their story towards the issue which are relevant to their defenses. For example, if the case involves a breach of the warranty of habitability, you need to focus on getting the client to 1. Describe the specifics of the uninhabitable conditions in detail. 2. Determine how long the problem has been going on. And 3. Determine whether and when the client has put their landlord on notice about the problem. Oftentimes, the clients won't initially tell you about all of the facts that you need for their defenses because they may not even know what facts are relevant to defending their case. That is why, as a final step, you should develop a checklist of general questions to ask to illuminate any other possible defenses which may exist. For example, inquire about the method of service in which the summons and complaint were served on the client. If you discover that the summons and complaint were not served by the plaintiff in compliance with statute, then you have the grounds for a motion to quash. If it's a non-payment of rent case, you can ask whether the landlord has ever rejected any amount of rent that the client attempted to pay. Is the client disabled? If so, has the client ever requested their landlord to provide them with a reasonable accommodation? And if so, what was the landlord's response? Lastly, you should also determine what the client's goals are. For example, do they intend to fight the case, and do they want to stay in their homes? Or do they want to move out, but they just need more time to do so? Through these steps of triaging the case, you may also determine that the client has no legal defenses to the eviction. At this point, you should have a hard but necessary discussion with your client, letting them know that they will not likely be able to stay in their home. You should discuss moving out options, how much time they may need to move out, and develop a strategy of requesting additional time to move out of the property. Special cases, initial client interview when the client has a default judgment. Oftentimes, you will encounter clients who come to you at the latest stages of the eviction. They've already been served with a default judgment, possibly even a writ of possession and a 5-day notice to vacate. At this point, your interview should be focused on two related issues. First, you should find facts to support a motion to set aside the default judgment. For example, was the service of process improper, or were there other extenuating circumstances that might suffice to set aside the default, such as the client was hospitalized or possibly out of the country at the time. Second, when moving to set aside a default judgment, you are still required to submit a proposed answer as an attachment to your motion. Therefore, you still need to direct your interview to uncover any facts which are relevant to defenses. In some cases, even if there's not enough evidence to support a motion to set aside the default judgment, it is still possible to save the tenant from being evicted or otherwise obtain more time for them to vacate their homes instead of being locked out by the sheriff. I highly encourage attorneys to utilize post-judgment motions, such as a motion for relief from forfeiture under Code of Civil Procedure 1179. Even if the court rejected the tenant's legal defenses to an eviction, or if the tenant defaulted, as a matter of equity, the court can restore possession of the premises back to the tenant as long as the tenant can establish there was severe hardship which outweighs any prejudice to the landlord. Hardship which the tenant experiences must be more severe than the ordinary hardship faced by a tenant in an eviction. For example, is the tenant sick, elderly, a single parent, or suffering from disabilities? Those may be facts sufficient to persuade the court of hardship. But homelessness alone, without something more, is not sufficient to show beyond ordinary hardship. 1179 motion can only be used where the tenant has the financial ability to pay back the landlord any amount of back rent. Therefore, it is not practically available for many non-payment of rent cases. However, it is very useful in cases such as a no-fault eviction where the tenant is financially able to continue paying their rent to reside at the property. If all else fails, you should attempt to move for a post-judgment stay of execution under Code of Civil Procedure Section 918. Therefore, during your interview of a post-default judgment client, you should be focusing on finding facts to support hardship. You should also inquire about the client's financial situation to determine whether they're eligible for a motion for relief from forfeiture or a motion to stay the judgment. Conclusion: through these steps of triaging the unlawful detainer, you will develop a strategy of quickly and efficiently developing the facts of your case and mapping out the basics of your legal strategy for the remainder of your case. Alternatively, proper triage of an unlawful detainer allows you to rapidly determine whether you cannot assist the client in any meaningful way and move your resources onto cases where you can make a difference. We hope that this video will make that kind of a difference for you in your practice. If any of these opportunities sound like a fun and meaningful challenge to you as an attorney or as a great way to give back, please reach out to us at Veterans Legal Institute for volunteer opportunities. You may visit our website at www.vetslegal.org